Hello guys, and welcome to another episode of my lecture. On today's episode, we will be discussing about removal of directors, section 2881. This provision is a very interesting provision because it has been litigated upon severally by Iwuchukwu and Iwuzu's case, by Longe and First Bank's case, by Bumioni and Kabri's case, by UOO and Okafor's case. You will see each of those cases have been discussed in the course of the lecture. But right now, let us understand what it is to remove a director. Then we would understand as well in this particular class what period of office is. Because to the particular extent, when we are interpreting the case of Iwuchukwu versus Iwuzu, period of office was a very important determining factor. But how did it play out? Let us see. When we are talking about removal of a director, then we have to go to section 288 subsection 1 of Cama 2020 that tells us that a company may by ordinary resolution remove a director before the expiration of his period of office, notwithstanding anything in the articles or in any agreement between the company and him. Now, do you understand that? I want us to break this thing down. Let us start with the first one. A company. The company there is not the board of directors, but the members in general meeting. How do we know that? Because it says may be removed by ordinary resolution. So we have to go to section 258. It says a resolution is an ordinary resolution when it has been passed by a simple majority of votes cast by members of the company has been entitled to do so, vote in person or by proxy at a general meeting. A resolution is ordinary when the members vote at the members in general meeting by simple majority. So we know here that they are talking about the members in general meeting. So the powers to remove directors is in the members in general meeting by virtue of section 288 subsection 1. The powers to appoint is in the members in general meeting as well by virtue of section 2731. However, the exception can be found in section 2741 and in section 46 sub 3. Now, let's go to the other part. It says that a company may by ordinary resolution remove a director before the expiration of his period in office. Now the question is, how do we determine the period of a particular director? I will discuss about that very soon. And then it says, notwithstanding anything in its articles, number 1, in any agreement, number 2, between the company and him, which means that the members in general meeting can remove a director at any time, even while they are going against their articles or while they are going against their agreement with the person. Do you understand? 3 things we need to note. They can remove by ordinary resolution. Secondly, they can remove before the period of office expires. Thirdly, they can remove notwithstanding anything stated in the articles or in the contract of employment. That is the agreement. Now that we know this, we need to know that section 259 talks about written resolutions. And written resolution says that if you cannot pass this particular resolution when the members in general meeting has convened, and you want to pass it by a written resolution when they are not in session, that means when they've not convened, then that written resolution must be signed by every single member that is supposed to sign. When you read section 259, it says all resolutions shall be passed at general meetings and are not effective unless so passed. But in the case of a private company, a written resolution signed by all the members entitled to attend and vote are valid and effective as if passed in general meeting. You need to understand that. But when we are talking about the removal of a director, you should know that section 292 subsection 1 tells us every director is entitled to receive notice of directors meeting unless he is disqualified by any reason under this act from continuing with the office of director. You need to learn that. Now that we know all these things, we know what section 2881 tells us, we know what ordinary resolution in section 258 says, we know what written resolution in section 259 says, we know that in 292 they said that there must be notice. Now let us go to the period of office. A director's period of office may either be stated in the contract or in the statute. It may be stated in the contract of employment or in the act or articles. Now, statutory period applies to those without stated period of office in their contract of employment. Contractual period is contained in the agreement between the parties and the company in the contract of employment. Where there is a contract, the year stated / fixed is the period of office of the director. Do you understand that? But do not forget that section 288 sub 1 empowers company to remove directors before expiration of his period of office. So we then go to this very important question, that is it possible for one to be without a period of office? And if there is no fixed term, can it be said that such director has no period of office? Or is there anything like director at will? This is the question that we are going to be answering in the case of Iwuchukwu Emmanuel J versus Engineer David C. Nwizu and others. I will see you in my next class.